Despite the COVID-19 pandemic disrupting almost all professional events, on July 23rd, Legal Plus and L2 Icon jointly managed to hold the fully virtual Construction Claims and ADR Conference 2021. The conference was participated by 44 moderators and speakers from 9 jurisdictions. With such a star-studded lineup, we had high hopes the conference would be a success, and true enough, the conference achieved its target by seeing an incredible 1,534 registrations. Not only that, the conference also set a new record in the Malaysian Book of Records for the longest non-stop virtual construction and ADR conference, when the conference ended after a 12-hour marathon at 9 p.m. Although the conference ended on July 23rd, its impact is still ongoing, and it is why we organized this charity premiere to let the conference see the light of day again, and at the same time to show compassion and empathy in our community. Let's watch the show together. It was this experience that became the spark for us wanting to help more people. We approached charitable organizations that help feed the poor, needy, homeless, orphans, abandoned, refugees, mentally disabled children and adults, the handicapped, animals, medical care, and help for children's education by providing used laptops and computers. If there is one thing we learned during the course of this initiative, is that there are many good people in our society, and many charitable organizations are going above and beyond to help those around them. For this charity premiere, we have carefully selected 10 charitable organizations, and we implore you to donate. Even a small amount goes a long way for them. 100% of the funds collected will be distributed equally. This initiative also helps raise awareness, the work these organizations do, and the people they have an impact on. This is the very reason why we are organizing this charity premiere, and with your help, we can help those who help others. Session 5 was a very relevant topic to many because it discusses the subject of money with regards to a dispute on whether you should pay now or argue later, and if a statutory adjudication is a good option to consider. Please sit back and relax as you enjoy the show.
We are honored to have Justice Dato Lim Chong Fong as our moderator for Session 5. Justice Dato Lim was appointed as Judicial Commissioner of the High Court of Malaya in 2014 and confirmed as the Judge of the High Court of Malaya in 2017. Justice Lim is now the Judge of the Construction Court in Kuala Lumpur. Ladies and gentlemen, please welcome Justice Dato Lim.
Thank you, Madeline. Welcome to Session 5 and good day to all. The topic for Session 5 is Pay Now and Argue Later, a key hindrance to an effective statutory adjudication. Now, I think most of you all would know statutory adjudication in Malaysia is brought in by the Construction Industry Payment and Adjudication Act 2012, in short, the CIPA. Malaysia is the 5th country to bring in statutory adjudication, which started in 1996 in the UK, followed by various states in Australia in the early 2000s, and then in New Zealand in 2002, and Singapore in 2004. Basically, the aim of the CIPA is to cure the ills of construction payment problems that plagued the Malaysian construction industry since the 1990s. There were many players complaining of non-payments, and many consultants at that time complaining they were all suffering in silence. So the aim to introduce statutory adjudication is to provide a solution to the problems that have been ongoing for a long time. So to make it work, there are two key features in statutory adjudication. One is swiftness and the second is a binding decision, albeit temporarily. The SIPA came into force in Malaysia on 15th of April 2014. So it's around now for almost 7 years. Datuk Sundaraju, who is going to be a speaker afterwards, has given me the moniker that I'm the father of SIPA because I formulated it and I lobbied hard for it. So it's a privilege for me to now have the opportunity to supervise and take care of the growth of this baby of mine in the past 2 years as judge of the Kuala Lumpur High Court, Construction Court 1. Now the poser is that law has not always been upheld, and pay now, argue later regime has something gone wrong. Now, when we were formulating the SIPA, Professor Nusrat Nasim, a previous speaker on simple language contracts, envisaged that the SIPA would be, in his words, a runaway success. And what I can say, perhaps as judge, is perhaps to share certain judicial statistics and let you make your consideration and conclusion as to whether SIPA has worked in the last 7 years. From the construction court statistics of the Kuala Lumpur Construction Court, as well as the Shah Alam Construction Court. Of course, there are other high courts in the other states of Malaysia. I do not have the statistics, but what I'm going to read out briefly would be the numbers we have had since the inception of the SIPA. So in 2014, there were 9 cases filed. 2015, 52 cases filed. 2016, 207 cases filed. 2017, 305 cases filed. 2018, 415 cases filed. And 2019, 459 cases. These cases include both setting aside as well as enforcement, and I think certain applications for stay as well. I do not have the statistics for 2020, but I believe it has gone down because of the COVID-19, as well as that there was no director in the AIAC last year. So a lot of appointments have not been made. So with the new director having come in now, so adjudications are starting again under the SIPA. Well, in a seminar organized by the Master Builders Association of Malaysia in 2019, I was informed by Mr. Rajendra Rawanatnam, my former partner in Asman Davidson and Co., also a speaker earlier. Now, he did some analysis on the cases, and what he found is that he has compared the court cases, the statistics versus the AIAC statistics over the last 7 years. And he concluded that only 25% of those cases go to court. So in other words, there is 75% success. And from my experience and basically from my own court, I find that about 90% of the setting aside cases fail. So in mathematical terms, we can probably conclude that there is probably 90% success. So I also like to hear from the speakers as what they perceive, and we shall hear from them in due course. Now for today, the organizers have arranged 3 eminent speakers, all well-versed with statutory adjudication, to share with us their views. And they are from 3 different jurisdictions. So I will look forward to hear from them. I will introduce each one at a time when their session or presentation is to begin. Each will have 15 minutes, and perhaps I'll ring a bell near the 15-minute mark to mark the conclusion. So now we have discussed earlier, so the order of the speakers would be based on the order the countries introduced statutory adjudication. So we will therefore start with Mr. Nicholas Ghoul, followed by Mr. Christopher Choi, and finally Datuk Sundaraju. So perhaps let me introduce Mr. Nicholas Ghoul at this point. He hails from the United Kingdom. I have known him for quite a number of years because we have met in previous seminars, both in the UK and in Malaysia. He is dual qualified in quantity surveying and law and has more than 30 years professional experience. He principally practices as adjudicator and solicitor and is a partner of Fenberg Elliott LLP. So Nicholas, I now invite you to share with us your experiences with the UK Housing Grant, Construction and Regeneration Act 1996. Over to you.
Very good. Thank you very much indeed. It's a real pleasure to join this conference and a real pleasure to see you again. It would be so nice, wouldn't it, to all be together, but such is the way these days. One of the great things, of course, about these events is that we get to reach out to more people worldwide. So I'm just going to now focus on some aspects of adjudication, such as it is under English law and taking place within the UK. The theme is pay now or argue later, and I think that's really, very much true of adjudication in the UK. So if I just then take you on to my first slide. What I'd like to cover here is statutory adjudication in the UK, and this is under legislation called the Housing Grants, Construction and Regeneration Act. Now that came into force in 1998, so it's been with us for quite a long time. Further legislation came into force in 2011, making some minor changes, but in reality now we've had, and turning to the second theme, enforcement of UK decisions for over 20 years. And I want to have a look at some of the aspects in relation to this process of English adjudication and some of the decisions, and also have a look at some of the exceptions to enforcement. So a brief overview then of the Act. The operative part of the Act is very short. So here it is, section 108, sub 2 of the Act. And this introduced the adjudication regime. So it was a real, I think, surprise for many in the industry. And if you're a lawyer, governments don't interfere that much in commercial contracts. There are implied terms, of course, but here we have a dispute resolution process that's imposed on the construction industry. You don't have to use it, but if a party to a construction contract instigates adjudication, the other party has no choice but to defend themselves. So these are the provisions that you have to include within your contract, and if you don't, they're implied in any event. So a party needs to be able to give notice at any time, and that's quite crucial, that wording, at any time, of their intention to refer a dispute to adjudication. So at any time means during the life of the contract, during the limitation prescription period, so under English law, 6 or 12 years. So it could happen at any point. And I know if you compare this to other processes, Singapore, for example, the trigger is the payment procedure, and you have so long to then refer your dispute to adjudication. But here, we could refer a dispute today about a payment that was made last year, or a defect that came up a year or two ago. So it works in a different way. Then there has to be a timetable which has the object of securing the appointment of an adjudicator within 7 days. And to start with, I think people thought this was very fast. It seemed rather a quick thing to be doing. If you were used to old-fashioned arbitration, which in England took, many months for you to have an appointment, and then many more months to actually get going. And here, an adjudicator is appointed within a short period. Now, the nominating bodies in the UK became used to this and make appointments within a couple of days, so that's not been a problem. Then the adjudicator has to reach their decision within 28 days of the referral, or a longer period, but only if the parties agree. Interestingly, the party that refers the dispute can extend the adjudication period by 14 days. So if you're defending, you can't extend time. In fact, the adjudicator cannot extend time, but the referring party can. When I sit as an adjudicator, if I feel I need more time, then and perhaps because the submissions are increasing, usually the parties will agree, or the referring party will agree, and you may be able to reach an agreement with both parties, because the option really is the adjudicator feels they can't make a decision, they can resign, and the whole thing would start again. So there's usually a little bit of pressure on the parties to agree a sensible timescale. Also, it's in the parties' interests to let the adjudicator have enough time to read the documents. And as you can see here, you could have a final account adjudication, which may have many, many aspects to it. The adjudicator must act impartially and can take the initiative when ascertaining the facts and the law. So there's the key provisions of the Act. Now, the adjudicator's decision is temporarily binding until it's either settled or set aside by litigation or arbitration. So this is the pay now, argue later point. If I have a decision against me, then I need to pay and argue about it later. So the decision, whilst not, permanently binding, as it were, will be enforced by the courts. And this is quite important because the courts very quickly made it clear that they would enforce these decisions. And there's very limited grounds to resist enforcement of adjudicators' decisions. So here they are: lack of jurisdiction, a material breach of natural justice, and maybe fraud has been something that's crept along more recently. So looking then at the types of challenges that you might see, jurisdiction or natural justice, this is the only way in, really, that the Court of Appeal emphasised early on that they will enforce decisions. Now, this first case here of Bouygues and Dahl Jensen from 2001, so 20 years ago, in that case, the Court of Appeal said that they would enforce decisions, the court should enforce decisions on this pay up now, argue later basis. Now, in that case, they also made it clear that an error of law or an error of fact was no good as a grounds for challenge. And actually what had happened in that case was that sorry, let me close this window. The truck's going past, I'm afraid. Very sorry about that. Typical. So what happened in Bouygues and Dahl Jensen was that the adjudicator had made an error. So when the calculation was done at the end of the decision, he paid the wrong party. And that party who was receiving the money was about to become insolvent. So the other party said, well, this can't be right. If we pay and we all know it's an error, and then the other party becomes insolvent, we'll never get our money back. And the Court of Appeal said, well, you have to stand by these decisions. We will enforce this decision. They did actually stay the payment pending insolvency, but they made it clear that any errors will not be a satisfactory basis for challenge. So what the court does is simply look to see whether the adjudicator has acted in excess of their jurisdiction. There's two parts to this, I suppose. The threshold test: did they have jurisdiction? Were they appointed by the right nominating body in the contract? Those sorts of procedural issues. And then if they have been appointed properly, they've crossed the threshold, they're into the dispute, do they lose it somehow by breaching the rules of natural justice? So a couple of examples of these cases, I won't run through them all, but in one of the cases here, a party rang up the adjudicator and had a conversation with them in the absence of the other party. That's a breach of natural justice and not acceptable. But in the Court of Appeal cases again, they've made it clear that judges must be very astute to examine technical defences and make sure that they are not successful with these technical challenges. Carillion and Devonport, quite an interesting case, 16 years ago. Let's just have a look at that case. And on the next slide here, you can see the brief quote from the Court of Appeal there. What they're saying is that when you look at the overwhelming number of cases that are brought to try to avoid payment, you have to look at them very skeptically and very carefully. And to seek to challenge the adjudicator's decision on the grounds that he's exceeded his jurisdiction or breached the rules of natural justice, save in the plainest of cases, is likely just to lead to a waste of more time and money in the court. And what you tend to see, just focusing at this point in time in 2005, was probably 2,500 to 3,000 adjudications a year. That's looking at the appointments made. And when you looked at the number of cases coming through, most of them were not successful in terms of challenging the decision. So it also appeared around this time that about 98% of adjudicators' decisions were just complied with, just a couple of percent were challenged. And out of that, out of the challenges, very few were successful. So the courts made it quite clear here that if you're going to adjudicate, you take it seriously, you defend yourself, you deal with the issues there and then, and live with the decision. If, of course, the decision is wrong, or you have more adjudications potentially, and the whole dispute sort of jigsaw puzzle doesn't look quite right, you can then, of course, arbitrate or litigate. But again, I think only around 2% of those cases that go to adjudication actually go on to some further form of dispute resolution. So just my last slide, looking at fraud. I've picked up on this because it's sort of an interesting one, really. You know, fraud, once you mention fraud in a commercial context, you do start to wonder if the arbitrators have jurisdiction. And so when you look at adjudication, you start to wonder if an adjudicator carrying out what is basically a contractual decision-making process could have any jurisdiction. So in this first case here of SG South, it was clear that there wouldn't be a challenge where a fraud allegation had been raised and the adjudicator had dealt with the commercial aspect of it. And same in this next case of Grosvenor. The fraud allegations were not brought, and the idea was to bring them later at enforcement and say, well, let's bring them in front of the judge, that's the right place. But the judge there said, well, no, if there are fraud allegations that impact on the commercial decision making, then you need to bring them in front of the adjudicator, that's not good enough. However, in this last case, the Siemens Eurocom case, if the decision is somehow procured by fraud, or there's evidence which shows that the materials put before the adjudicator are fraudulent, then that's different. If the process has been derailed by fraud, then they won't enforce it. But these cases, I must say, are very rare. We have nearly 700 reported cases in the past 20 years. The vast majority of them enforce the decisions. Although there are still seemingly issues that crop up about procedure and process, I think we're fairly clearly now in this world of quick-fire decision-making using adjudication in the construction industry. And just to finish, a couple of key points, I suppose, in relation to the change in the industry that I've seen. So when I was doing arbitrations 25 years ago, you probably spent 3, 4, or 5 years to get to your award. Then we entered this world of 28-day decision-making, and arbitrations have just disappeared. People don't arbitrate domestically anymore in England. Sometimes for specific things, but rarely. They just go to adjudication. And this might mean you have 2, 3, or 4 adjudications on a project, but it's cheaper, it's quicker. People mostly live with the outcome. The impact on the court. So the court was similar going back 25 years, 3 or 4 years to get into court to get your judgment. Well, after about 5 or 6 years, the court was only taking, the technology court was only taking about 12 months, and it's still the same now. So if you start a court matter in the technology court, construction technology court here, you end up with the whole process being 12 months, maybe slightly longer. So it's very quick and very efficient. The reason being that the quick fire valuation, extension of time claims, they all go to adjudication. So the court gets left with dealing with the complex matters, the multi-party matters, the ones that involve defects or collapse and insurance, things that are not really suited to adjudication at all. And of course, enforcement, and enforcement can be dealt with rather quickly. So there we are. That's my quick breeze through the UK approach to adjudication. And I'm happy to take questions or wait for the other speakers, whatever you would like me to do next. But thank you.
All right. Thank you, Nicholas. I think we will take questions after all 3 speakers have completed their presentation.
Thank you. Thank you.
All right. So we will move next to Mr. Christopher Choi. He hails from Singapore, and I've also known Christopher for many years, since his days practicing in Drew and Napier. He is dual qualified too in law and surveying, and has more than 30 years of professional experience. Principally, Christopher practices as adjudicator and advocate and solicitor in Singapore. He is a partner in a Wong Partnership LLP. And Christopher is also a senior accredited specialist in building and construction law by the Singapore Judiciary. So Christopher, I invite you now to share with us your experience with the Singapore Building and Construction Industry Security of Payment Act 2004.
Thank you very much, Judge, for the very kind introduction. If I may just share screen now. Well, essentially, most of you here would be familiar with the security for payment regime. I mean, you've got that in Malaysia, and we have our own security for payment legislation as well that has been with us since 2005. So in that sense, we have a longer history. Now, the security for payment regime in Singapore is also characterized by its efficiency, in that there is a very short time period for adjudicators once they've been appointed to render their decisions. And essentially, they have to render their decisions within 2 weeks unless both parties agree to extend time. However, in the year 2019, there was a revamp of our legislation following feedback from the industry. And these changes that have been made to our legislation have been described by some to be quite controversial. And some would even argue that these amendments, some of these amendments, as well as certain case law developments, which I'll speak about, have made inroads into this pay now, argue later principle. So what are these changes here that I'd like to talk about this afternoon? Now, firstly, when the amendments were made to the security for payment legislation, there were changes made to a number of items. One would be the time period given for a party to serve the payment claim. Now, prior to that, a party generally had 6 years to pursue a claim through adjudication from the time the work was done. But this period has now been shortened or bridged to only 30 months, all right, or 2.5 years after the job was completed or the project was completed, as the case may be. Secondly, provisions were also introduced through these amendments to allow the paying party to suspend payments following termination of the contract in certain situations, which we'll talk about. And the third major change that was effected by these recent amendments relates to claims for what we call damages, loss, and expense. Now, many of you here will be familiar with such claims, particularly in the context, for example, of claims for prolongation or disruption, or conversely, counterclaims or back charges for liquidated damages for delay that the employer may wish to impose on the contractor. But now, by virtue of certain amendments to the legislation, the adjudicator will be required to disregard such claims in adjudication unless they fall within certain exceptional cases. Now, in addition, there have also been a number of important judicial cases which have clarified the law. And I'll just touch very briefly on some Court of Appeal decisions which have made certain pronouncements that impact the future of adjudication here in Singapore. So I'll start first with the limitation period. Now, as I pointed out earlier, under the old legislation, a party essentially had 6 years to pursue a claim. So this could include a lot of the final account claims that we were talking about, where despite attempts to try and resolve these claims amicably, they could not do so. And the contractor or the supplier, as the case may be, would be able to pursue his claims through adjudication. Now, that period has now been abridged to 30 months. And the underlying policy rationale behind that was that it would not be fair to a party who has to pay to deal with a claim made 4, 5, or 6 years, after the project has been completed, because by then the employees or the documents may no longer be available and people may not be around anymore, to deal with such claims. Now, the second important amendment that's been made by the recent legislation relates to contracts which are terminated. Now, of late, because of the pandemic situation and so forth, we have also seen a surge in such cases. Now, the definition of a contract under the SOP legislation has been amended to embrace contracts which are terminated. However, a new section 4.2, which was introduced through the amendments, provides that the Act will not apply to terminated contracts to the extent that the terminated contract contains provisions relating to termination that permit the respondent to suspend progress payments to the claimant until a date or the occurrence of an event specified in the contract, and the date has not yet passed or the event has not yet occurred. Now, many of the current standard form contracts are aligned with this position. For example, one very common form of contract used in Singapore, the SIA building form of contract, provides that in the event a contract is terminated, the architect would not be obliged to certify any more payments due to the contractor until such time as the work is completed by the replacement contractor and the cost of termination have been ascertained and a certificate issued. So by reason of this, what it means effectively is that contractors whose contracts have been terminated, rightly or wrongfully, may now find themselves in a position where they have no recourse to adjudication under the Act, where such provisions exist that allow the respondent to hold back or to suspend payment in that sort of situation. Now, the third major change, and this is one that attracted a lot of controversy when it came out, was that relates to loss and expense claims. Now, prior to these amendments, such claims were permitted so long as they relate to construction work payable under the terms of the contract. And in this sense, I mean, we follow closely, the various judicial authorities in New South Wales, in the UK, and so on. But now with the new section 17.2a, an adjudicator will be obliged to disregard such claims for damages, loss, and expense, except in two very limited situations. The first situation is where you could show that both parties had agreed to the quantum of these claims. Now, it's very important to emphasize that it's not good enough for them to agree on just the entitlement. The agreement must extend to the quantum as well. All right, this is obviously going to be a very rare sort of a situation. Alternatively, such claims are only permitted now to the extent that the claim can be supported by a certificate or other document that's issued pursuant to the contract. Now, the implications of this are tremendous, because such claims used to constitute a significant part of a lot of these claims that we used to see in adjudication. I myself have acted as an adjudicator in claims involving loss and expense in excess of 10 million. It's not uncommon. But now, in the light of these amendments, it appears that the claimant can no longer prosecute a claim for prolongation costs through adjudication unless the respondent had previously agreed to the quantum or it's supported by certification. That means the claimants will now have to resort to other avenues, such as arbitration or litigation. So in that sense, this pay now, argue later principle has in a way been eroded. Now, Parliament has explained its intention behind this, and the argument was that, or the rationale is that such claims, given their nature, are often very contentious, very complex. They involve delay expert reports, expert evidence, and so on. And adjudication may not be the best forum, to deal with such claims. Now, what is very interesting, though, is that this rule applies both ways. It cuts both ways. It's a sword that cuts both ways. Just as the claimants cannot prosecute a claim for damages, loss, and expense, the paying party or the respondent likewise can no longer set off or counterclaim for such loss and expense unless they themselves are brought into the exceptional circumstances that are contemplated under the Act. Now, moving on, there have also been some important Court of Appeal pronouncements which have clarified the nature of the contractor's claim or entitlement to be paid under the SOP Act. Now, let me explain briefly. If you look at, for example, the New South Wales legislation, what they clearly say is that there is a dual track regime provided. In other words, apart from your contractual entitlement to be paid, there is a statutory entitlement to be paid pursuant to the security for payment legislation. However, recent Court of Appeal decisions in Singapore have now clarified that a contractor's entitlement to be paid under the security for payment legislation stems or arises from the underlying construction contract under which the works are carried out. And in this sense, we have not followed the New South Wales cases, and our Court of Appeal has come down clearly to say there is no dual track regime. In other words, the Security for Payment Act does not in itself grant the contractor a right to be paid. It is no more than a legislative framework to expedite the process by which a contractor may receive payment through the normal payment certification process. And this was laid down in two cases, Shibitsu against Stargood Construction, and the Court of Appeal case, Far East Square against Yaoli, which I was involved as counsel as well. So in other words, there's no longer a separate statutory entitlement to a progress payment. And if a contractor wishes to pursue a claim adjudication, he must first establish that he's entitled to do so pursuant to the contract. So for example, in the Far East case, the Court of Appeal found there was no basis for a contractor to submit a payment claim after the final certificate had been issued under the SIA form of contract, which is the standard form contract used for commercial projects in Singapore. And the basis of this reasoning was that under the contract, the architect's duties were concluded, or the architect was functus officio once the final certificate had been issued, and the entire certification machinery would come to an end. Similarly, in another case, Court of Appeal decision, Shimizu against Stargood, the Court of Appeal likewise found, on the basis of a bespoke contract, that there was no basis for the subcontractor to submit a payment claim after the subcontract had been terminated, because the subcontract terms precluded the service of payment claims after termination. Now, these principles were again reaffirmed more recently in another Court of Appeal decision, Orion 1, where the Court of Appeal found that there was no basis for a main contractor to submit a payment claim after termination of the main contractor's employment, as the terms of the agreement could not constitute the basis of any entitlement to serve payment claims after termination. Now, of course, these decisions have tremendous ramifications for contractors and developers alike. Before a contractor can make a claim for progress payment under the regime or under the legislation, it is imperative as a threshold requirement that he must establish that he's entitled to such payment under the contract in the first place. Now, potentially, what this means is that the applicability of the Act and the pay now argue principle can, in a sense, be circumvented by the inclusion of terms in the contract which could circumscribe or limit the contractor's entitlement to payment. Now, of course, having said that, such terms which circumvent or circumscribe the contractor's right to payment will still be subject to review under Section 36 of the Act, which precludes parties from contracting out of the Act. So in closing, I just want to make some observations that whilst the old security for payment regime has certainly adhered to the pay now, argue principle, question is that how much of this has been eroded by these recent amendments and cases. For example, in the Orion 1 case, a very, very recent Court of Appeal decision, the Court of Appeal actually observed that it doesn't make sense for a contractor to apply for adjudication of a payment claim more than 2 years following termination of its employment and about 2 years after the project had been completed, because any adjudication determination would only have what we call temporary finality or temporary binding effect, and would in any event still be open to review or correction in any pending arbitration. And basically the Court of Appeal urged parties to do a proper cost-benefit analysis, especially towards the tail end of the project, to see whether it's worthwhile to pursue a claim in adjudication rather than to have all these disputes hived off to a more suitable forum like litigation or the courts or in arbitration to have the parties' substantive rights adjudicated with finality. Now, ultimately, it appears from the various judicial pronouncements on this subject that the real intent of the SOP Act is to facilitate cash flow on an interim basis whilst the project is afoot. But once the contract has been terminated or when the project is coming to an end, that those very reasons may not be applicable anymore, and may be far better to have these disputes resolved in the appropriate forum, which carries an element of finality. So on that note, thank you very much for this time, and I'll be happy to take questions later.
Right. Thank you very much, Chris. But before we take questions, let's move on with Datuk Sundar Raju's presentation. Datuk hails from Penang, Malaysia. In fact, Datuk and I share the same alma mater. We came from the Penang Preschool. And I've known Datuk for many years now too, not in school, but when I started practice. I've appeared before him in several arbitration proceedings then I was practicing as counsel. Datuk Sundar is multi-qualified. He holds qualifications in architecture, town planning, and law. And he has more than 40 years professional experience. He is a chartered arbitrator, practicing principally as an arbitrator presently. In fact, Datuk Sundar and I, we have locked horns earlier during the conception stages of the SIPA. I was the strong proponent and he was the strongest opponent. So without further ado, can I invite Datuk Sundar to now give us his presentation.
Thank you, Justice Lim. It's very candid of you. I'll try to be this. Can we start our slides, please? Thank you. Slide 2. Actually, the ever-broadening growth of construction industry, particularly in Malaysia, came with a lot of problems related to construction payments disputes. The introduction, I think, as Justice Lim has said, of the Construction Industry Payment and Adjudication Act, which came into effect on 15th of April 2014, was actually a dispute rehearsal mechanism to resolve construction contract payment disputes. Now, it is also a unique statutory regime which only exists in a very limited number of jurisdictions. I mean, countries, United Kingdom, New Zealand, Australia, Singapore, Canada. The first one, of course, I think Nicholas has said it's first started there. The rest of the world, over 180 countries don't have it. So it is a unique experiment meant mainly for construction industry of these countries. So everybody is watching this, how we are doing it. In fact, we have 3 models that we have seen just by this presentation. I will argue on the model that we have in Malaysia. The next slide, please. Okay. Now, basically, I'll go to the next one. Thank you. Next slide. Okay. Now, SIPA has flourished under the Malaysian construction industry. It has created thousands of jobs. It has actually created an entire industry. A lot of people have become very, very comfortable and prosperous. And the mantra has been to pay first and argue later. Now, this is supposed to be an interim measure to facilitate cash flow in the construction industry, as often they say that litigation and arbitration are very lengthy processes and more costly. Now, the Housing Grant and Construction and Regeneration Act actually started this. And SIPA itself instilled this overall concept of pay first, argue later. And we can see this in the following provisions. Section 8.3 states that the parties to the adjudication can be represented by themselves or anyone. This goes to show that SIPA 2012 is, as a legislation, is not meant to be too legalistic. Now, Section 37 states the Act intends to run concurrently with other dispute resolution methods. Section 29 empowers the unpaid party. It gives the successful party a right not found in common law. It gives the successful party a right to suspend work until the adjudication sum is paid. And then Section 30, it is intended to allow direct payments requested by an unpaid party from a non-paying party upon obtaining another right that is not found again in common law. It allows successful parties to get direct payment from principals. Now, so next slide, please. Now, there are landmark cases. I think it's very interesting, Justice Lim has said. When I was director of the center, I believe the cases were 900. And if 400 cases were there, That means there is a lot of cases that are actually being adjudicated in the courts after the adjudication is completed. So basically, the courts have upheld generally pay first and argue later mantra, which is that you accept that you will have to implement of the adjudication decision. But however, the case law that I've been observing is shifting away from this mantra. Instead, it's now open to, again, even if that 25% or the limited number of adjudication decisions are actually being set aside, when they are set aside, it actually sends a message. So, but generally, the reception of SIPA has been seen as a positive one by the legal fraternity, particularly, and the construction industry, although the construction industry has now some reservations. So there are some issues, and the real issues have been settled at the federal court level, because I think we have a 3-tier system. It starts from the High Court, Construction Court, then it goes to the Court of Appeal and to the Federal Court. And the landmark cases first is Uda Holdings Berhad versus Bisraya Construction Sdn Berhad, and another View Esteem Sdn Berhad versus Bainapuri, Ireka Engineering Construction Berhad versus PwC Corporation, with a joint hearing in Jack and Piles versus Bauer. Next slide. Now, Uda Holdings versus Bisraya, it actually was a very interesting decision because it was early when I was director of the center. And as director of the center, when this decision came, we had to implement it. And it decided that SIPA was retrospective in its operation. And by applying Section 41 of the 2012 Act, it appears that basically that it was not only a saving provision, but also a transitional provision. And it applied retrospectively to pre-existing payment disputes. Now that actually gave a boost. I mean, the unintended consequence is suddenly there was a boost. The number of cases shot up because people went back and dug up their old cases and started to apply for it. Now, the federal court has actually reversed the decision. It has said basically in Jack and Pyle and Bauer that it took a different approach. It said that SIPA is prospective. So we have a situation where there's a ding-dong. So next we go to the next important case. Next slide. View Esteem. Now, View Esteem is a very important case. In fact, it departed, in my own analysis, from the pay first and argue later because of the reasoning that the federal court used in deciding the question of law. Now, the common practice of adjudicator in applying Section 6.4, it is stated that if someone does not respond to the payment claim, the non-paying party does not respond to the payment claim, you are deemed to have disputed the entire payment claim. Now, it can be considered as a deeming provision where Parliament has imposed this as a legislative presumption on the non-paying party. But the federal court in View Esteem held the adjudicators are now not precluded from considering all defenses raised by the respondent in adjudication response, even if such defenses are not included in the payment response. Now, the critical discussion of the case is in Section 6.4 of SIPA, allowing the responding party to raise matters not raised in the payment response under Section 6.2 or during the filing of the adjudication response in Section 6.10. Basically, it reversed the entire exercise to a backhand procedure. So first, generally, I'm going to the next slide. What is the current standpoint now in Malaysia? Is it argue first, pay later, or pay first, argue later? So the first thing is that the right of the adjudicator to exclude defense at the payment response stage. Now, View Esteem position, prior to this, the payment claim and payment response were treated as a letter of demand combined with pleadings, which is like Order 18 of the Rules of Court in adjudication proceedings. Now, the adjudicator then would be only confined to matters that are raised in the payment claim and payment response. The defense must be raised by the respondent in the payment response in order to be allowed to raise it in the adjudication response. Now, post-view esteem position, the federal court has actually deciphered a very different nature of the payment response in section 6.2. It requires the non-payment party merely to state the amount disputed and the reasons for the dispute, whereby the adjudication response in section 10 of SIPA, on the other hand, requires the respondent to answer the adjudication claim, meaning the nature and description of the dispute and remedy claimed by the claimants in its adjudication claim. The court said that the latter is more appropriate to give a legal response together with the opportunity to raise any defense. The adjudication proceedings begins with issuance of an adjudication notice. The adjudicator is then appointed. Next, where the cause of action arose, it is identified in the adjudication claim brought by the unpaid party, otherwise known as the claimant, under section 9 of SIPA, just like a statement of claim in civil proceedings. Then it contains the nature and description of the dispute and remedy sought. Now, it is interestingly, it is now common for non-paying parties not to file a payment response at all and raise their defense at the first stage. And this actually, in order to actually organize their defense and documents and strike back hard at the adjudication response stage with voluminous documentary evidence. And it is no longer the law that if a non-paying party fails to fulfill the first stage, the respondent cannot raise any defense at the later stage. Next slide, slide 8. Now, SIPA has its challenges. Late payment has always been a hindrance in the Malaysian construction industry. And I think to achieve the second construction industry master plan, which is aimed at strengthening the Malaysian construction industry, which provides about 8%, employs about 8% of the total Malaysian workforce and contributes significantly to the Malaysian GDP. Now, the next slide. There is a cash flow problem because of the structure of the Malaysian construction industry. And then too often there has been pay when paid, all this has been banned. Conflict is actually endemic, it is adversarial, and it is actually cash has become quite important. So I will agree that the intention of the act was actually very noble, and to actually facilitate cash flow, like what Lord Denning said, there's been a large volume of complaints due to late payments and non-payments, but it will defeat the very purpose if we have forgotten the fundamental nature of adjudication to let the third party resolve. There are many legally trained adjudicators, but the disputes actually deal with quantum disputes. In fact, it was my complaint when I was director that there were not enough construction professionals becoming adjudicators, because most of the disputes, the larger disputes, were being decided by legally trained adjudicators with just legal training, and who tend, I've looked at some of the adjudications. When they are faced with a quantum thing, that's where the experts come in. They have to have assistance. Then the next thing that happens is that they tend to actually half it, and you can't actually question it, but because this is my own experience looking at adjudication decisions, not very satisfactory, but I've accepted that is part of the system. But of course, those adjudicators will not agree that this is what they are doing, because it's the nature. Now, the court has also set aside, next slide, set aside a number of adjudication decisions on trivial grounds. For example, I feel like Guanzi Development and Capital Sdn Berhad versus Cycle Berhad and another. Basically, the court set aside the adjudication decision because there was no hearing conducted. Now, by virtue of Section 25G of SIPA 2015, the adjudicator is under no duty to conduct a hearing. So this seemingly opens up that the adjudication decision can be challenged by unsuccessful parties in the adjudication. Of course, it can be said you can appeal it and get it corrected finally. but that actually gives a problem at that point, because the adjudication is already set aside at the High Court, then going to Court of Appeal, it may even go to the Federal Court. Then next one is NASA Engineering and Construction Sdn Bhd versus SSL Development Sdn Bhd. The court set aside the adjudication decision on the ground that the adjudication granted late payment interest, which was not included in the late initial payment claim. Then Tekun Cemerlang versus Vivek Construction Grants Project Sdn Bhd. They applied the law relating to legal professions in East Malaysia to say that it has basically the appointment of adjudicators is under the Act itself is not restricted to locality. So in fact, there's only one adjudication body, which is AIAC, and the appointment is actually not based on where you're practicing. So I think there is a need to distinguish adjudication proceedings from court proceedings, or perhaps even arbitration proceedings. So the speed, the effect of all this is that the speed of the entire adjudication process is hampered. Now, basically, once it goes to court, it actually counterbalances the spirit of pay now and argue later. So we are treating adjudicators akin to legal practitioners such as advocates and solicitors, subject to territorial jurisdiction. Perhaps this has to be relooked again. The overreaching effect of unenforced adjudication decisions. On the other hand, the courts seem to be giving too much weight to adjudication decision, despite being an unenforced decision pursuant to Section 28 of CIPA. Now, traditionally, for an arbitration award to be considered to play its part in a winding up proceeding, it must be first registered in the court, as can be seen in Mobicom Sdn Bhd versus IMIS Communication Sdn Bhd. But in the case of Likas Bay Prisin Sdn Bhd and Benapuri, despite the clear wordings of Section 28 of CIPA, the courts allowed the adjudication decision to be used in commencing winding up petition. Now, this uncertainty shuttling back and forth with ASM Development, Sdn Bhd and Ecopal disallowed, and the later decision of Maju Holding Sdn Bhd versus Spring Energy Sdn Bhd allowed adjudication decisions to be used for winding up position. Now, there is another point that I want to make, which is quite troubling for me, is that there is no provision similar to Order 69 in arbitration in the court rules requiring setting aside of adjudication decision, let's say within a duration of, let's say, 90 days. That's allowed in. That would provide finality. In 2018, I worked with the Courts Rules Committee under AIAC to introduce such a provision in the court rules. All was agreed. Then, however, it was not implemented. So that leaves a lacuna, which is now exploited by non-paying parties to launch a legal challenge against decision despite the lapse of time. So we need to actually now go to the second last slide, slide 11. What are the reforms that we need to look at? I think first we have to deal with View Esteem case and Benapuri, so that the element of surprise where parties withhold documents and information until the later stages of the adjudication process and ambushes another person can be removed. So I think this has to be relooked, and the current Section 6.3 allows only a time frame of 10 days for the non-paying party to serve a payment response upon receipt of a payment claim. It is suggested maybe this window be expanded to 21 days. Then by virtue of Section 6.4, when parties fail to serve a valid payment claim response within the stipulated 10 days, it shall be deemed to have disputed the entire payment claim and will not be allowed, this is what should be there, should not be allowed to raise a positive defense in the adjudication response. So you take the first part quite seriously, so that there's a front loading and so that the dispute itself is actually dealt with at the front. I think we can look at a number of items, but I'm very attracted to the approach that Singapore is taking by understanding that we also had the same feeling when we departed from the idea of not having not having all disputes to be decided. We wanted only payment disputes. I'm going to the last slide, the conclusion slide. It should not be treated like a mini arbitration without finality. So the main upside is that it is confidential as compared to litigation, and all these things is good. People will discover adjudication as attractive sometimes towards a settlement of their disputes. But there is actually a problem of a lack of awareness. And I think the subcontractors, and if someone has deep pockets, they can actually take you until in the court process until the end. I think there are no winners in this. What we wanted was something that was very simple. But the problem basically is that when we put in final claims, final payment, final accounts, it became the stakes became very high. And so I think everybody has actually come in and sort of tried to delay the payment, actual payment, and buying time. And I think legal cost is not cheap. I think one thing we must understand, legal cost is never cheaper. I think that's one of the main problems that we have when we deal with this kind of situation. So I feel that that's all I have to say. But I must say at the end, it is one of the best things that happened to Malaysian dispute resolution, because we have a system that needs to be tweaked. Once it's tweaked, I think it will fall into place with all the other systems and support each other. So I'm not saying that everything is wrong with it. In fact, because I helped to set it up, we have actually got 900 cases when I led. And I can imagine that it will be basically very successful. But if we continue like this, it will reduce. It will only go to small cases, because the big cases, the persons will say, I will not go to adjudication because I will end up in the federal court, even if it's dismissed, because you still have an appeal until the last court. And I might as well start another dispute resolution mechanism. And if there is no finality, arbitration in Malaysia now is quite final. If there's no finality, I will just leave and go somewhere else. So I think this, we have to be careful. So I think we need to actually re-look at the industry again. Thank you. Thank you, Justice.
All right, thank you, Dato'. So now we will open questions from the floor. I have noted that we have several questions here that have been sent in online. Perhaps the first what I see here is that are there far too many decisions referred to court, adjudication decisions? Maybe a quick one from each of the jurisdictions.
Shall I go first?
Yes, please.
Okay, so I don't think so. No, if you look at the size of the industry in all of the countries we've been talking about, the industry is huge. It's the greatest contributor to the domestic product, isn't it, of that country, employs more people and so on. So it's a massive industry, and we only get a little snapshot into it. And certainly if I think about the non-contentious work, I see there are plenty of successful projects that go very well. So I don't think there's too much. I think actually it's a great tool, and it's more economic than having a full-blown court action. In many instances, that's our experience in the UK.
All right, Chris, Singapore?
Okay, the Singapore situation is a bit more unique because Singapore, unlike all the other jurisdictions, have what we call a review procedure, meaning it's similar to like an appeal. If you are dissatisfied, the respondent can actually ask for review. So there were two avenues open to a party to challenge a determination. One is to go by way of a review, in which case it's heard by another panel of adjudicators, or you go to court to have it set aside. So prior to the amendments in 2019, there were many cases which were referred to court for the simple reason that the respondent would prefer to pay the money into court pending the outcome of a challenge. But now with the amendments, That is been reduced because it provides that if you go for a review, you don't have to pay the other party immediately, but instead you can pay the adjudicated sum to the nomination body, which is the Singapore Mediation Centre, to hold as security pending the outcome of the review. So following the amendments, we have seen a significant drop in the number of applications to court to challenge. Going forward, I think the number of cases will decline dramatically.
Thank you. Dato', you have any comment on this?
Yes, I'm just looking at the Justice Lim. Dato', you did mention the number of cases that are in the courts now, and if I remember the statistics that we have of the number of cases, and we must say, out of those number of cases, there are small cases, there are medium-sized cases, and then there are very large cases. So actually, the very large cases is inevitable from what I see that it will go to court. And we actually need to analyze, if we have 400 plus cases, we need to analyze in terms of breakdown. Is it an enforcement exercise? Is it a setting aside exercise? Because sometimes when you try to enforce, the person will then raise a setting aside. So it really be two actions again. So I think the cost, adjudicators are complaining they are being paid very poorly for deciding the thing. But at the end of the day, the actual cost the parties may end up paying is very much larger. So I think that is where the real problem it is. I also see another thing that is happening, the use of experts. It is like arbitration. It is, expert reports sometimes can go, depending on the kind of disputes, very large sums of money, which is even higher than whatever the adjudicator who's deciding is paying. I mean, the adjudicator's fee may only be, let's say, about 20% of what the expert is getting to appear to describe something which we all envisage. I think Justice Lim, you would also, we all envisage that the adjudicator should be able to decide that without that kind of help. Remember we always were talking about that this is what we wanted. And we wanted something that was quick, that was fast, that was reasonably priced, and more importantly, less avenue for review by the courts, and then pay first, argue later. Then you can go to court to re-litigate the same matter or to arbitrate the same matter. The re-litigating the same matter would be let the court decide the whole thing that has been. So I think, again, this is the difficulty I see, but it is not, all is not lost. I think we are looking at the Singapore example. I'm quite attracted to some of the ideas there, make controversial or not controversial. Even, when we came out with SIPA, we also talked about whether loss and expenses was actually a damage clause. Can it be enforced? The feeling at that time was it cannot, but the courts, of course, followed the other jurisdiction. There's limited examples that are available. It's either an Australian case or it will be a British case, English case, but then very limited. So you tend to follow that, although the wordings are slightly different. So I think we need to relook at the legislation to tighten it. Go back to the original concept. It is meant for small people originally. If it's meant for big people, then you take the risk, at that point of time. I think that's the way we have to do it.
All right, thank you. Now, the other question is that the effectiveness of it, because the question is, there are a lot of stay applications that follow with the setting aside applications. Therefore, it's also not helping in pay first, argue later. The payment gets stuck. Any comment on this?
Sorry, when you say it gets stuck.
Stuck meaning the unpaid party has not been paid, notwithstanding having obtained a positive decision.
Yeah. I mean, our in the UK, the payment regime legislation is separate to the adjudication regime, but they do fit together. And when there was a change to the Act 10 years ago, some of that was adjusted to try to deal with this problem, make it very clear that you can't set off against a payment notice, and if there isn't a payment notice, then you can yourself, as a party receiving money, serve a default notice, and if there isn't a pay list notice against that, they have to pay that amount. So it started to head in that direction, but really adjudication still becomes the answer in order to, get to your money and then the court to enforce it still. So we do see situations where a very reluctant party just won't pay you, and if the notice provisions haven't been dealt with, there's a short, quick adjudication about it, meaning that you can then go and enforce and use the power of the court to enforce. So I think a lot of this actually has all been about the first step, providing a quick process, providing payment mechanisms, providing this quick adjudication process. But secondly, really to get you to enforcement so much more quickly than a long trial or an arbitration, where the power of the local court can make the party do what it's supposed to do.
All right. Any stay problems in Singapore, Chris?
No, not really, because in the Singapore payment regime legislation, I mean, essentially there are four main avenues if you're not paid your adjudicated amount, some of which are in the nature of self-help remedies. So, for example, you can stop work, suspend work if you're not paid by giving notice, or you can ask for direct payment from the employer. And in certain cases, you have a lien over any unfixed materials or goods that are supplied. You can go back. So enforcement, of course, by going to the courts to have it registered, that's obviously available in all instances, and there's been a very high success rate of enforcement as far as Singapore adjudications are concerned.
Right. Maybe for the Malaysian one, I'll just share 1 or 2 points from my own experience, because the stay comes in two scenarios. One is pending setting aside of the decision, and the other one is pending final determination, either in arbitration or in the construction court. So usually the setting aside is disposed very quickly. So that stay will go very quickly. It's the second one that has caused problems. But understandably, then we have to go into the principles behind stay against statutory adjudication. But I think the good news I can say is that from my decisions so far, the second type, the very minimum is a payment into court or into a solicitor's account. So in a way, there is security, because unless the winner can show good financial position, otherwise the stay may have to be ordered. But the loser will have to pay something. There's no free lunch of not paying. I think that's the intermediate solution.
Judge, I was just thinking that can we go back to the original idea that if you get an adjudicator's decision, unless it's set aside, you just pay first. And then, there must be limited reasons why you can actually, even payment into court, sometimes it is not money in the hands of the guy who cannot, he doesn't have the cash flow. So I'm very sympathetic with the situation that some people are going on, because they just don't know when they are going to get the money. So they are worried. And then I suppose, this is where we need to actually clarify. I would still go back that if you do not actually mount a setting aside within 90 days, then it is enforceable per se. And then you have to pay. If you bring something, then you have to ask for an extension of time. There must be some tests like hardship or whatever it is. Then after that, you must pay. Even payment into court is not a solution, but more importantly, pay first unless it is shown that you are totally insolvent. Then I think we should take it as a requirement that these two parties have been dealing together. They have an understanding of each other, and they should perhaps take the risk as it falls at that point, and not raise that this person cannot actually pay back. They took the contract, So I think, I'm just being very practical about it. I look from a policy point of view rather than just the law, because the policy I think is very important. That is why I find the Singapore approach, they are looking at policy all the time and how to get it working rather than the various incidences of how the courts rule and all these things, because at the end of it, it may not only help, but it also causes a lot of burden. The amount of cases, let's say 400 cases, we have how many specialized construction courts now in Malaysia?
Two in KL, one in Shah Alam.
One in Shah Alam, and then all the other high courts are also handling construction cases, mostly from SIPA. So, we just add the cases and we can see already what is the cost to the nation. So I think we need to actually look at that. So I feel that we can tweak it to make it better.
All right. Looks like we just ran out of time, although I've got several other questions here. So perhaps what's left is to thank all of you all for sharing your experiences, and it has been a wonderful session.
Adjudication in Malaysia is alive and well, and our panelists agree that it should be revised to make it stronger to see more widespread adoption. Tomorrow, we will highlight a variety of topics from several distinguished speakers on how to manage expert witnesses in arbitration, managing parallel proceedings in construction claims, and more great topics.
So it's not like a typical loan or an insurance. And it really is unique for 4 central reasons.
That the report or the evidence is prepared on a factual basis, either which is contested or which may in fact be erroneous.
When fraud should not be raised as a defense, when there's no direct impact. So an example of that would be
when we talk of dispute resolution in general and construction claims in particular, I guess what comes to mind, at least to my mind, are the various dispute resolution processes.
And I wish to speak on the issues relating to variation instructions and valuation rules.